the district attorney falsely made up a court date, May 23rd, 2025, and drafted a fraudulent subpoena that if Aetna did not provide documents on that date, it would be in contempt of court. But this is not the first violation, in my view, illegal violation that the New York prosecutors have carried out against Mangione. They also accidentally eavesdropped on his phone calls with his attorneys. Hey, it's Jordan with Status Coup.
This is Ashley with Status Coup.
On the ground.
In Philadelphia.
Flint, Michigan. East Palestine, Ohio. Please support the leading independent news outlet on the ground.
Covering what the corporate media covers up.
Hey, it's Jordan with Status Coup. Prosecutors in the New York case against Luigi Mangione, the alleged shooter of United Healthcare CEO Brian Thompson, made up fake court dates to illegally steal Mangione's full medical records, thus violating his HIPAA medical rights. That is the claim and argument that Mangione's legal defense team has made in an explosive and I think bombshell court filing just yesterday. This is pretty big news. As part of it, Mangione's attorneys are seeking remedies, including dismissing the entire indictment against him in the state of New York. Let me give you the overview here. Again, this is in Mangione's New York case, not his federal case, but it could have ripple effects. Mangione accuses prosecutors of fudging subpoena for his health records. Luigi Mangione's defense team lambasted Manhattan prosecutors on Thursday for, quote, plainly lying on a subpoena to nab their clients' confidential health records. Mangione's currently awaiting a pair of murder trials after he was accused of gunning down United Healthcare CEO Brian Thompson in December. Quote, the district attorney falsely made up a court date, May 23rd, 2025, and drafted a fraudulent subpoena that if Aetna did not provide documents on that date, it would be in contempt of court. Mangione's claims in a New York Supreme Court document filed yesterday. Before I get to this specific document, I want to give you the broader context because there's been so many moving parts with this case, and I've been trying to keep up on it, but obviously we've been covering the ICE Gestapo prison known as Alligator Alcatraz and other things. But this is not the first violation, in my view, illegal violation that the New York prosecutors have carried out against Mangione. They also accidentally eavesdropped on his phone calls with his attorneys, which there seems to have been no consequence for. I'm going to read some of the court filing that Mangione's attorneys filed yesterday. I'll put the link in the description if you want to read this court filing. Dear Judge Caro, Luigi Mangione, through his counsel, submits this letter to raise yet another significant issue of misconduct on the part of the district attorney. The district attorney has subpoenaed Mr. Mangione's health insurer, and if their account is to be believed, they partially reviewed confidential, private, protected documents that the district attorney readily admits are protected by the Health Insurance Portability and Accountability Act, HIPAA, which is the grand standard, the gold standard of medical privacy and is law. That's me adding that. That's not in the subpoena. Excuse me, not in the court filing. There is no question that the district attorney has no right to possess or review these documents. They did not seek a court order, nor did they secure a waiver from any party. Moreover, the information is not relevant to their case. Accordingly, at a minimum, the district attorney has admittedly violated Mr. Mangione's rights under HIPAA and has obtained access to confidential, privileged information. However, the situation is far worse than this. As set out fully below, the district attorney's subpoena was false and fraudulent. The district attorney falsely made up a court date, May 23rd, 2025, and drafted a fraudulent subpoena that if Aetna did not provide documents on that date, it would be in contempt of court. Then rather than having Aetna give the documents to the court, as required by the already fraudulent subpoena, the district attorney told Aetna to provide the documents directly to the district attorney, intentionally eliminating the court from the subpoena process and ensuring that the district attorney would secure these confidential medical records without either the court or Mr. Mangione's counsel knowing or being able to object. Had they followed proper procedures required by law, this grievous error would never have happened. I'll get back to that, but I want to zero in on this and make sure you share this video. Please support us as low as $5 a month as a paying member. We have led the charge uncovering Luigi Mangione's case, as well as the murderous for-profit health insurance system. I don't even call it care. But we need your support to do more. StatusCoup.com/join. $5 a month equals 16 cents a day. But important part here that essentially, I mean, it was pretty clear. I've been following the closely. There was no court date on May 23rd. There was no court date that I remember in the New York case in May. There were court dates that kept getting delayed for the federal case. But in New York's case specifically, there was no court date for that date. So where did this court date come from that the prosecutors told Aetna, you have a deadline of May 23rd to get us his medical information from Aetna, which was presumably his health insurance company? Somebody's got to explain that, because that seems like a blatantly illegal fraudulent subpoena. Because the district attorney has taken possession of and at least partially reviewed Luigi Mangione's confidential doctor-patient privileged and HIPAA-protected medical records, and further because the district attorney misused the subpoena process to obtain these protected records, this court should impose an appropriate sanction after conducting a full evidentiary hearing to uncover the extent and nature of the significant privilege and HIPAA violation intentionally caused by the prosecutors. Specifically, the defense requests discovery of all communications, written and oral, between the district attorney's office and Aetna, as well as hearing where sworn testimony will be taken from, among others, the following people. And then they list names from the prosecutor's office that wrongly and I believe illegally obtained his medical information, as well as the Aetna representative that provided it. Based on the facts developed at this hearing, combined with other violations of Mangione's rights, including an admitted prior violation of his attorney-client privilege, we ask that the court consider a range of appropriate sanctions to include dismissal of charges, precluding the people from accessing the HIPAA-protected materials they secured by an unlawful subpoena, and or recusing any member of the district attorney's staff, including the assigned ADAs, from further involvement in the case. Let me get into the specifics of the unlawful subpoena here. On May 14th, Assistant District Attorney Joel Seidemann drafted and signed a subpoena duces to sum to Aetna Health. The subpoena commanded Aetna to appear before the Supreme Court of the County of New York at the Supreme Court building on May 23rd, 2025 at 9 a.m. as a witness in a criminal action prosecuted by the people of New York against Mangione, and to bring with you and produce the following items: the account number and period of time during which the following individual received coverage, Mangione. The return date of the trial subpoena, May 23rd, 2025, was not a court date for this matter. There was never a court proceeding scheduled for May 23rd, nor was there ever a court appearance scheduled for the entire month of May, which I just referenced earlier. Rather, this is a completely made-up date, which is not permitted by law, as trial subpoenas must only be returnable on a court date to the court. As a result, by commanding Aetna to appear on May 23rd, 2025, and to provide the materials under pain of being, quote, adjudged guilty of a criminal contempt of court and liable to file of $1,000 and imprisonment for 1 year, the people were plainly lying to get the materials as soon as possible. So let me break this down for the layman. According to Mangione's attorneys, and they're damn good attorneys and high-priced attorneys, so I think they know what they're talking about and aren't making this up, the New York District Attorney's Office essentially invented a court date, made up a fake court date that didn't really exist, to put a gun to Aetna's head to provide Luigi Mangione's legally HIPAA-protected medical records. And if you don't provide the medical records, you're going to be faced with jail time or serious fine. This coupled, by the way, with the previous violation of the New York District Attorney's Office accidentally eavesdropping on an 11-minute phone call Mangione had with his lawyers. I got to tell you, I'm no lawyer. I have watched Law and Order, though, and it seems to me there is the lawyers for Mangione are setting up an avalanche of constitutional violations of his rights for appeal, for a potential appeal if he is convicted. Let me go back further, because it does sound, if this is true, and I have no reason to believe it's not true, that the prosecutors were plainly lying to basically steal his medical records. The people's unlawful subpoena requested 2 items from Aetna. 1, Mr. Mangione's account number. 2, the time period during which Mangione received coverage from Aetna. In its June 12th response to the subpoena, Aetna violated HIPAA and unlawfully produced the prosecution's 4 files containing its, quote, entire designated record set related to Mr. Mangione. The records were 120 pages of what the people concede was private, confidential, protected medical information within the purview of HIPAA. In addition to being HIPAA protected, the materials are also clearly within the scope of the doctor-patient privilege, as they contain statements made by Mangione to healthcare providers in order to receive medical care and treatment, as well as medical diagnoses. Indeed, the materials received by the district attorney pursuant to the unlawful subpoena put the people on clear notice that the materials were in fact confidential under HIPAA and were privileged, each of which will be addressed below. The people were on notice that the materials were protected under HIPAA. First, the cover letter from Aetna stated it was from the HIPAA member rights team, which appeared both on top of the cover letter and the signature line. I mean, this is either serious amateur hour at the New York District Attorney's Office, which I don't think they're amateurs, or they're just brazenly don't give a fuck and are violating the law. I'm going to go with the latter. I mean, you don't need to be a lawyer to know HIPAA is one of the most basic, gold standard legal protections for Americans, so that your medical information, whether it's diagnoses, conditions, whatever, are between you and your doctor and nobody else. You have to actually fill out forms to give permission for your medical records to go to a spouse, a loved one, as part of HIPAA. But somehow the New York District Attorney's Office is getting a whole avalanche of his medical diagnoses, communications between Mangione and doctors, which, by the way, why is that relevant to his case or their prosecution against him? Beyond fishy. A lot of smoke. On June 16, 2025, a conversation took place between ADA Kaplan and a named representative at Aetna. This is the only conversation referenced in the email. However, it may not be the only one they had. ADA Kaplan states that the Aetna representative advised that, quote, Aetna mistakenly provided the defendant's entire designated record set to the people. ADA Kaplan further explained that the representative said that this mistake occurred, quote, because the defense has served Aetna with a subpoena for the designated record set materials around the same time the people served the above described subpoena. This statement is false, as the defense did not serve a subpoena. Mangione's attorneys conclude the subpoena. In conclusion, the district attorney's office violated well-established subpoena laws by falsely creating a court date, accepting subpoenaed records that should have been returnable to the court, and reviewing medical records that were clearly protected by the doctor-patient privilege and HIPAA. In addition, we request full evidentiary hearing with sworn testimony by people with knowledge of how the subpoena was drafted, how Aetna was directed to provide this information to the district attorney instead of the court, who reviewed the produced protected materials, who was told about the protected materials, and who supervised the process. In addition, based on the evidence developed through this discovery process and the requested hearing, the defense reserves the right to seek various remedies, including the recusal of the prosecution team, suppression of evidence, or dismissal of the indictment. The mistakes are piling up for the prosecution against Luigi Mangione. Speaking of piling up, in good news for Mangione, because this is not good news when your HIPAA, your private medical records, are illegally stolen by the New York District Attorney's Office, he got a $50,000 donation to his criminal defense fund. Mystery $50,000 gift supercharges Mangione's fight. Another anonymous donor has supercharged Luigi Mangione's defense fund, this time with a $50,000 boost that has reignited grassroots enthusiasm and the debate around one of the nation's most polarizing criminal cases. The large donation, made anonymously on July 16th, so 2 days ago, marks the single largest contribution to date in the ongoing fundraising campaign for Mangione. The donor, anonymous, left this comment with his donation, quote, "I already knew about the life-saving treatment denials of cancer patients like my mom and severely ill elderly, plus the Senate investigative report." The donor wrote in a message posted alongside the donation, quote, "I'd hear her crying of pain," speaking of his mother. "It's always been messy for legal purposes. This is unrelated to any litigation." There was another anonymous 36,500 donation to Mangione's fund in March. But this $50,000 donation is the largest donation ever made to his legal defense fund. And so far, he has raised $1.2 million from donors all across America. So that is major news. We will keep you updated. The New York District Attorney's Office is certainly going to have to respond to this bombshell. I would say explosive document court filing by Mangione's attorneys, and my guess is they're going to be twisting themselves into a pretzel to try and rationalize or explain how the hell they got Luigi Mangione's full medical records. Please support us as a paying Status Coup member so we could continue covering this. We're going to be covering the trial when it happens, expected to happen early 2026, we believe, but we're going to stay on this and update you along the way. StatusCoup.com/join for as low as $5 a month. That's 16 cents a day.